What is motion for protective order? A motion for protective order is a formal request asking the judge to issue a protective order that limits, delays, or conditions access to information or regulates conduct during a case. In the common law world, especially the United States, the term is used mainly in two settings. 1. Civil litigation to manage and shield the discovery process, and 2. Family criminal contexts to protect a person from harassment, stalking, or violence, no contact or stay-away orders. A bit of background. The Federal Rules of Civil Procedure, 1938, opened the gates of discovery. Later amendments, especially in 1970, clarified that discovery is broad but not boundless. Rule 26C emerged as the pressure valve. Even when information is relevant, courts may restrain discovery to prevent annoyance, embarrassment, oppression, or undue burden, expense. In parallel, state legislatures built fast-track mechanisms for personal safety, allowing temporary protective orders, sometimes even ex parte, when there's imminent risk, followed by a full hearing. How does it work in civil discovery? The moving party bears the burden to show good cause. Typical grounds include privacy concerns, medical or financial records, trade secrets, safety risks, e.g. doxing, or sheer disproportionality, millions of emails for a minor issue. If granted, a court may A. Narrow the scope of document requests or interrogatories, B. Change the time, place, or method of depositions, C. Order that certain materials be filed under seal or used only within the case, D. Require redactions of sensitive data, E. Protect trade secrets through tiered confidentiality, confidential versus attorney's eyes only, or F. Shift costs or impose conditions. When a subpoena to a non-party is excessive, a protective order often travels with, or as, a motion to quash. Practical mechanics matter. Many courts require a pre-motion meet and confer to try to resolve disputes in good faith. Supporting declarations should spell out the harm or burden in concrete terms, time estimates, costs, sensitivity of data. Judges may review materials in camera to decide. The remedy must be narrowly tailored, no broader than necessary. Violations can trigger sanctions. In complex cases, parties often stipulate to an umbrella protective order, later approved by the court, that sets classification rules and handling protocols up front. A handy doctrinal cousin is a FRE 502D clawback order. Inadvertent disclosure of privileged material does not waive privilege, reducing the fear and cost of privilege reviews. What about personal safety? A motion for a protective order in domestic violence or harassment cases seeks immediate person-focused relief. No contact directives, minimum distances, temporary possession of the residence, surrender of firearms, and sometimes interim custody or visitation rules. Typically, a temporary order issues quickly, with a prompt hearing, often within 7 to 21 days, on a longer-term order. The proof standard is civil, preponderance or similar, lower than the criminal standard. Willful violations can be prosecuted as crimes or punished as contempt. Concrete examples: trade secrets. A startup asked to produce all source code moves for a protective order limiting production to the relevant module under AEO, accessible in a supervised review room without copying. Disproportionate e-discovery. A small business faces a demand for 10 years of emails from 200 custodians. It moves to limit to core custodians, targeted keywords, and a 24-month window with cost shifting. Personal safety. After credible threats, a petitioner obtains a temporary no-contact order. The court sets a hearing in 2 weeks to decide an order lasting 1 year. Exam and practice tips. Be precise about what you are protecting. Information versus personal security. Who bears the burden, the movement, and why the remedy is proportionate. Remember that judicial transparency is the default, but it yields to compelling interests like minors' privacy, medical confidentiality, and trade secrets, hence the need for specific findings and narrow tailoring. Appellate courts usually review these orders for abuse of discretion, so a well-documented record is your best friend. Above, I've left more videos so you can keep learning law. Remember to leave us a like and subscribe.